This is Barry Zalma speaking for Claim School Incorporated. It's blog Zalma on Insurance. Today we're going to talk about why insurance dealing with the U.S. government can often be difficult to deal with, and why one must recognize the fact that there exists sovereign immunity, and it is very hard to sue the U.S. government without its permission. Roberta Jean Champlin appealed the decision of the United States Court of Federal Claims, dismissing for lack of subject matter jurisdiction her claim that the United States must pay damages for the non-payment of life insurance proceeds from her deceased former husband's federal employee group life insurance policy. In Champlin versus the United States, the U.S. Court of Appeals Federal Circuit on April 10, 2023, dealt with Ms. Champlin's request for payment of a federal employees group life insurance, FEGLI, policy after her ex-husband died, because her divorce decree granted her half ownership in the policy. Now, the Federal Employees Group Life Insurance Act, FEGLIA, establishes a group life insurance program for federal employees. The United States Office of Personnel Management, OPM, is responsible for managing FEGLI policies and it has entered a contract with Metropolitan Life Insurance Company, MetLife, to provide insurance to federal employees. FEGLI proceeds are to be paid in the following order of precedence: 1. Designated beneficiaries. 2. Widowed spouse. 3. Children or descendants. 4. Parents of deceased. 5. Executor or administrator of the estate. And 6. The next of kin. The order of precedence can be overridden if and to the extent expressly provided for in the terms of any court decree of divorce, annulment, or legal separation, but only if that order or decree is received before the date of the covered employee's death by the employing agency, or if the employee has separated from service by the OPM. When these circumstances are met, the proceeds shall be paid in whole or in part by the OPM to the individual who is entitled to the proceeds under the court order. Louis Dean Champlin, during and after his marriage to Ms. Champlin, had life insurance through a FEGLI policy. In September of 2012, the Champlins divorced. As part of their divorce proceedings, Ms. Champlin obtained from the Alaska State Divorce Court an award that Ms. Champlin had the option to continue maintaining a 1/2 interest in the policy, while Mr. Champlin had the option of paying the other half of the policy, and could designate whoever he chooses to be beneficiary of the other half of the policy benefits. Ms. Champlin paid for her half of the policy thereafter. What she didn't do was provide a copy of the court order to the OPM. On January 3, 2016, Mr. Champlin died. Ms. Champlin did not receive her half of the proceeds of his life insurance policy. Instead, the proceeds were paid to Mr. Champlin's designated beneficiary at the time of his death, Marilyn Susano. Ms. Champlin sued the United States in the Court of Federal Claims, alleging she was entitled to half of Mr. Champlin's issued life insurance coverage, and further requesting judgment directing the United States to pay her half of the FEGLI proceeds, along with costs and attorney's fees. Unfortunately for Ms. Champlin, the complaint failed to allege a statutory or legal basis for jurisdiction for her claim. The government moved to dismiss Ms. Champlin's claim for lack of subject matter jurisdiction on the basis that FEGLI-related claims cannot be made against the United States because the government has not waived its sovereign immunity for such claims. The OPM authorized MetLife to provide life insurance, and MetLife established an administrative office which is responsible for administering FEGLI claims. The Court of Federal Claims noted that it found that Ms. Champlin's complaint made no claim for breach of a legal duty, only a claim to obtain money due under the FEGLI policy. The Court of Federal Claims' determination that it lacked subject matter jurisdiction over Ms. Champlin's claim for life insurance proceeds from Mr. Champlin's FEGLI policy was correct. The Federal Circuit concluded that the Court of Federal Claims is a court of specific jurisdiction and can resolve only those claims for which the United States has waived sovereign immunity. The government's duties under the statute are limited to contracting with and managing private insurance companies that issue FEGLIA-compliant insurance to federal employees, as well as implementing regulations to support the FEGLIA's statutory mandates. Because the United States duties under the FEGLIA and relevant regulations do not extend to claims for proceeds due under a FEGLI policy, Ms. Champlin has failed to establish that the United States has breached any duty when insurance proceeds were allegedly due. Ms. Champlin sought money that she believes is due to her under the policy because she complied with a divorce court's order. The fact that the policy had already been paid out to another beneficiary before Ms. Champlin became aware of her alleged injury had no effect on the regulation's application. The court affirmed the Court of Federal Claims' dismissal for lack of subject matter jurisdiction, which also concluded that MetLife paid what it was required to pay because the divorce court order was never delivered to the OPM. In my opinion, Ms. Champlin sued the wrong party. If she had any rights, it was against MetLife. But apparently, since she failed to tell MetLife or the OPM of the existence of the court order, they had no obligation to pay her. She just wasted her money paying premium. The U.S. had no obligation under the FEGLIA statute and did not waive its sovereign immunity. Although she could have sued MetLife, she did not because she knew she could not succeed. Alaska's court order could not compel the U.S. to do anything, and if anything, her case is against the ex-husband's estate for not complying with the Alaska order to make her a designated beneficiary. The payment was made to a designated beneficiary, so MetLife did what it was required to do. A person can only sue the U.S. government if the government waives its sovereign immunity. Since it did not do so, Ms. Champlin had no case. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you will be advised of all the blog postings, usually 5, sometimes 6 a week. You can also subscribe to the videos at YouTube and at rumble.com. And if you do, I'd appreciate it if you like the videos to click on the like button on YouTube and the Rumble button on Rumble. And please tell your friends and colleagues so that they can also subscribe to the blog or the videos. And if you're interested in further, more detailed information about insurance and insurance claims handling, please consider subscribing to my Locals community or my Substack publications. Thank you for your attention.